Hi, I'm Daniel Rod, Senior Associate Lawyer at Ramsden Family Law. Today I'll be discussing the treatment of superannuation as an asset under the Family Law Act and the process of splitting superannuation in the context of a relationship breakdown. Superannuation is considered as an asset for the purposes of the Family Law Act. This means that superannuation is eligible for division between parties in the event of a relationship breakdown. And it's important to note that this applies to both married and de facto relationships. Superannuation is treated as a different species of asset in family law because it is considered a unique type of property that is subject to special rules and regulations. In property proceedings, superannuation is often considered as a separate asset class and may be divided between the parties in a different manner than other property. The reason for this is because superannuation is a long-term savings vehicle intended for the retirement of parties and is subject to different laws and restrictions such as preservation age and early access rules, which may impact its division in a family law context. The process of splitting superannuation, if done by way of consent orders or by way of court orders, is known as a superannuation splitting order. This order allows for a portion of the superannuation to be split between the parties. The amount can either be agreed or determined by the court. In a majority of cases, this is either a dollar amount or a percentage amount that's split. But broadly speaking, another way of splitting superannuation is through a superannuation agreement under the Family Law Act. This is a binding agreement between spouses or de facto partners that sets out how their superannuation interests will be dealt with in the event of a relationship breakdown. Superannuation can also be included in a binding financial agreement, which is a written agreement between spouses or de facto partners that sets out how their property and financial affairs will be dealt with in the event of a relationship breakdown. Binding financial agreements can include provisions regarding the division of superannuation interests and are legally binding if they meet the requirements set out in the Family Law Act. When it comes to superannuation splitting, it's important to note that the trustee of the superannuation fund must be afforded procedural fairness of 28 days. This means that the trustee must be given notice of the intended split and have time to consider the implications and provide their input. If you have any questions about how your superannuation will be treated as part of a family law settlement, please contact us at Ramsden Family Law and either myself or one of my esteemed colleagues would be really glad to assist you.